Property owners in Kerala often face a key question. If a roof, like a trusswork structure, is added over a terrace for protection from sun and rain, does this increase the building tax liability? This video explains a significant Kerala High Court ruling that provides clarity on this issue, focusing on the Kerala Building Tax Act, 1975, and the taxation of areas under such trusswork roofs. The issue was examined in a specific court case. Property owners constructed a trusswork roof over the terrace of their existing commercial building, primarily for weather protection. Subsequently, tax authorities recalculated the building tax, including the large area under this new roof, nearly doubling the taxable plinth area. The owners contested this, arguing the space wasn't fully enclosed or used as a standard room or commercial area. The dispute eventually reached the High Court for resolution. The central question before the court was whether an area under a truss roof, not fully enclosed, should be included in the plinth area for building tax assessment. The High Court's decision was clear: generally, no. The ruling highlighted that a trusswork roof built mainly for weather protection does not automatically make the space beneath it taxable. The crucial factors are whether the area is fully enclosed and actively used for residential or commercial purposes. If the space remains open or only partially enclosed and isn't utilized like a room or shop, it typically should not be assessed for building tax under the Act. The court provided further clarifications. Firstly, the presence of a parapet or safety railing on a terrace does not constitute full enclosure. For tax calculations, these are often mandatory safety features. Secondly, the type of use matters. Merely storing miscellaneous materials under the roof generally doesn't qualify as taxable commercial or residential use, unless those materials are integral to a business conducted on the premises, such as stock in trade. Likewise, using the terrace solely for ancillary purposes like drying clothes or general storage, rather than habitation or commerce, does not typically bring it within the taxable plinth area. Significantly, building tax assessment is based on the current state and use of the property. Potential future modifications or uses cannot be the basis for current taxation. However, the court acknowledged that if the terrace area is later fully enclosed and converted into a usable residential or commercial space, it would then likely become subject to building tax, potentially leading to a reassessment by the authorities at that future time. In summary, this Kerala High Court ruling, 2025 KHC Online 419, establishes that a trusswork roof added over a terrace mainly for weather protection generally does not increase building tax liability. The exceptions are if the area becomes fully enclosed and is used for residential or commercial purposes. Simple storage or ancillary uses typically do not trigger additional tax. The ruling also noted that tax benefits related to installations like solar panels are relevant only if new, taxable construction occurs after their installation. Disclaimer: this information is for general understanding based on a court ruling and does not constitute legal advice. Property tax laws can be complex, and individual circumstances vary. Consultation with a qualified legal or tax professional in Kerala is recommended for specific situations. If you found this video helpful, please like and share it with others. Subscribe to our channel for more legal insights.